Hi, my name is Andrea Shear. I am an immigration attorney with Pollock, Isaac, and DeSico. This is part one of a two-part video. Today, I will discuss what the new public charge rule is and who it affects. On my next video, I will discuss Form I-944, the Declaration of Self-Sufficiency, which must now be submitted to the U.S. Citizenship and Immigration Services. The new rule went into effect on February 24th, 2020. Public charge considerations have always been a part of the immigration system. However, prior to February 24th, there was a more lenient rule in place. The new rule makes it more difficult to immigrate to the United States. There are four major changes that I want to discuss today. First, the language of the statute changes to whether a person is likely at any time to use or receive one or more public benefits. This standard is subjective. It means that an officer will now look at a totality of the circumstances in order to make his or her determination. Public benefits or the receipt of public benefits will only be a factor. The officer will also look at income, age, health, employment, assets, skills, education, amongst other factors. Second, the rule expands the programs counted to include benefit programs that are not just cash benefits, such as SNAP, food stamps, non-emergency Medicaid, public housing, and Section 8. However, the rule does not include other benefits, such as emergency medical assistance, disaster relief, national school lunch programs, children's health insurance programs, amongst other benefits. The rule is not retroactive. Any application that was sent before February 24, 2020 will only be subject to the older, more lenient rule. Some amount of benefits is allowed. You can receive benefits, but it has to be in a period of less than 12 months in a 3-year period. The regulation doesn't apply to U.S. citizen children that receive benefits, even if those benefits are under your name because your child is a minor. Each benefit counts separately. This means that if you receive cash assistance and food stamps in the same month, that will count as 2 months that you have been receiving benefits. Third, the rule expands when the test is applied to now include those applications to change or extend non-immigrant visas, meaning that if you came to the United States as a tourist and would like to extend or change your status, you will be subject to public charge considerations. The fourth and final change that I would like to talk about is that the new rule reduces the weight given to the Affidavit of Support in the totality of the circumstances analysis. The Affidavit of Support usually accompanies every green card application. It is signed by a United States citizen or permanent resident sponsor who agrees to take care of the immigrant if the immigrant cannot take care of themselves. In the past, affidavits of support were sufficient to show that someone would not become a public charge. However, now it is only a factor in the totality of the circumstances analysis. Of course, there are many exceptions to the rule. It does not impact refugees, asylees, victims of trafficking, victims of crime, victims of domestic violence, and other recipients of humanitarian benefits. The rule only applies to you when you apply to become a resident and or when you apply to extend or change your non-immigrant visa. If you're applying for a green card, then yes, you're subject to the public charge rule, unless you fall under one of the exceptions I just described. Lastly, I want to let you know that there's a lot of information out there, and a lot of it can be very misleading. So please speak to an immigration attorney before you decide to terminate, continue, or start receiving public benefits. Stay tuned for part 2 of my video on Form I-94. Thank you very much.